The treaty, called the International Convention on Combating Bribery of Foreign Public Officials, ratified by Congress, is in full effect. In accordance with the treaty, the United States Foreign Corrupt Practices Act has been amended. Changes in the law affect all U.S. and foreign companies and their employees doing business in the United States and anywhere in the world. This updated edition of the Payoff reflects those changes. Introductory and concluding comments are by Martin Weinstein, who, at the time he appeared in the original version, was a United States attorney with the Department of Justice.
I had just recently and successfully prosecuted a case involving the Foreign Corrupt Practices Act. The case involved a major corporation and resulted in record fines and penalties. One senior executive actually went to jail. Since then, the Foreign Corrupt Practices Act has gotten even tougher. The law has been amended and expanded, and literally reaches around the world. Because of these and other changes to the U.S. Foreign Corrupt Practices Act, the cases and the messages in this film are more important to you and to your company than ever before.
Doing business abroad involves investment of time, resources, and capital. The risks are large. So is the expected payoff in corporate growth and profit. But some business people encounter expected payoffs of another kind. The following account is based on official court records. The story is true. But the company name has been changed to CC Limited, CCL. Individuals are not named. Their initials have been changed. A federal grand jury indicted CCL for violating the Foreign Corrupt Practices Act. The indictment charged 2 employees with conspiracy: the regional director of sales, Mr. A, and the regional vice president for marketing, a foreign national based in Switzerland, Mr. G. Named but not charged in the U.S. was the company's agent in a Middle Eastern republic, Mrs. J. In that republic, CCL was seeking to sell 3 pieces of equipment worth $25 million each. The company's agent, a consultant, was also an elected member of the national parliament. The consultant received a monthly retainer plus a sales agent commission of $300,000 for each piece of equipment ordered by her government. During negotiations, the agent's commission was doubled to $600,000 for each unit sold. Company memos and payment requests identified the agent by code names like the player, or your friend, or helper concession. The consultant sent a letter of resignation, creating an appearance that the agent relationship had been terminated. Subsequently, what were described as termination fees were paid to a numbered Swiss bank account set up in the name of the agent's husband. Despite continued payments to the Swiss account, CCL certified to the Middle Eastern state and to the U.S. that it was not paying commissions or fees in connection with the $75 million contract. FBI and grand jury investigations revealed that 1 or more executives at CCL had authorized these covert fees and false statements and records. Criminal indictments were handed down. Pending trial, the company's export licenses were suspended, and it was barred from bidding on U.S. contracts. CCL's regional director of sales, Mr. A, pleaded guilty and agreed to fully cooperate with the prosecution. The company, too, pleaded guilty. On the day set for his arraignment, CCL's regional vice president for marketing, Mr. G, fled and became an international fugitive from justice. The United States government froze his assets, while U.S. attorneys and special agents pursued him in Europe and the Middle East. At their instigation, when he attempted to resettle in his native country, he was arrested on suspicion of criminal activity in another nation. After 4 months in jail, Mr. G agreed to return to the U.S. and plead guilty. He received a fine of $125,000 and was sentenced to a term in federal prison of 1.5 years with no parole. Mr. A received a $20,000 fine, 3 years probation, and removal from any management role in international sales at CCL. He has left the company. The corporation's fine under the federal sentencing guidelines was twice its gain from the contract, taken to mean profit, resulting in a fine of $25 million. The force of United States law doesn't stop at the water's edge. It goes with you, anywhere in the world. When you represent an American company anywhere, you carry something along with your bags and business plans: the laws governing the way U.S. companies conduct themselves, and the law that prohibits bribes, kickbacks, payoffs to foreign officials. The Foreign Corrupt Practices Act, F.C.P.A.
You've got a company trying to sell a product abroad in a difficult market, and you got pressure, economic pressure, incentives, pressure on your salesman to close the deal. And if you're dealing with a corrupt official, he can exploit that pressure by offering to give you the deal in exchange for some payment. If you look back at the cases, some of them are as simple as, if you want to get paid, I'm going to need a percentage of the money. If you're going to want the contract, I'm going to need, my percentage. Different parts of the world use different phraseology, but it's all the same message. Quid pro quo. If you want this business, you're going to have to pay me.
In 1974, during an investigation by the Securities and Exchange Commission, some 500 companies disclosed highly questionable payments to government officials in Italy, Holland, Honduras, and other countries. In December 1977, as a result of cases like these, the Foreign Corrupt Practices Act became law as part of the Securities Exchange Act. In 1999, amendments went into effect in accordance with the newly ratified treaty, the International Convention on Combating Bribery of Foreign Public Officials. What happened at the company we've called CCL shows that you need answers to some important questions about corruption in the law if you're going to do business successfully in the global marketplace. Question: how does our F.C.P.A. regulate your business conduct in foreign countries? The Act makes it unlawful for a firm or an individual acting on behalf of the firm to offer, pay, or promise to pay anything of value to any foreign official for the purpose of obtaining or retaining business, or to gain any improper advantage. It's unlawful to make a payment to an intermediary while knowing the payment will be used for bribery. And it's unlawful for companies to keep records that do not accurately and fairly reflect the transactions of the corporation. Bribery, direct or indirect, and deceptive bookkeeping are the two main targets of the law. Question: who is covered by the bribery provisions of the Act? The law covers any citizen, national, or resident of the United States, and any foreign national who is an officer, director, employee, or stockholder of any American business enterprise. It also covers all American companies' domestic or foreign agents. Question: according to the Act, what is a bribe? A bribe is anything of value, money, gift, service, offered to corruptly influence an official decision to act or refrain from acting.
Bribery, talking about bribery. Quid pro quo. I'll give you something, you give me something in return. If those elements are present, then an American company is exposed to investigation and prosecution.
Who does the Act identify as a foreign official? A foreign official is an officer, employee, or any person acting in an official capacity for a foreign government, including any department, agency, military branch, court, or legislature, or for any public international organization. An employee of a state corporation should be treated as a foreign official. An outside consultant or advisor acting in an official capacity on behalf of a foreign government may be considered an official under the F.C.P.A. The Act also prohibits corrupt payments to a foreign political party or to candidates or officers of a political party. What does the F.C.P.A. mean by the word corruptly? You act corruptly when you attempt to achieve an unlawful result, or a lawful result by unlawful means. Corruption applies to the intent of the payer.
The Foreign Corrupt Practices Act is very specific in that the payment has to be made with corrupt intent. That means that the payor has to be making the payment for the purposes of corrupting the individual or the official office of the individual receiving the bribe. A prosecutor tries to make out that element of the crime by showing that the payor, the person who was making the payment or the bribe, was intending to get some favor or some special treatment by virtue of using the individual and the individual's office to receive favorable treatment in the host country.
Question: can you be held accountable for the acts of a foreign agent or other intermediary? Suppose you're trying to sell a system to a state-owned corporation in a foreign country. The manager has discretion to use funds for a system with your product specifications or to reallocate the funds to some other requirement. The manager's assistant recommends that you retain an agent with a reputation for getting things done in that country. The agent operates out of a small office with no staff. He advises that selling your system will require big marketing expenses, payments to bureaucrats at the Department of Economic Development to expedite permits and other forms, expense-paid trips by the manager to visit your plant in the States. Any warning signals here? Later, the agent informs you that these visits to your plant will entail wining, dining, gifts, and side trips in the interest of building a closer relationship. He requests money to pay fees to an unnamed consultant. A large expense allowance is to be deposited in a numbered bank account in another country to maintain confidentiality. Any danger signals? You tell the agent that normal procedure calls for written approval and detailed accounts of any expense over $500. He says this is not a normal situation. Detailed documentation will be difficult, impossible really. But he guarantees a good result. You ask, how? He says, you do not have to know how the trick works to enjoy the magic show. By now, the danger signs are clear. Your customer is a government entity. Even if you don't know the details, you do know there is a strong likelihood that corporate money will be used for bribery. The only way not to know is to close your eyes to the obvious and deliberately keep yourself in the dark. Deliberate ignorance is equal to knowledge in an F.C.P.A. case.
Many companies are concerned with the way they rise because of their dealings with agents or consultants. And these people in the past, in a number of the cases, have been the conduits for the payment. But it's always a request, and there's always something that comes up. If you're going to get the business, you need to do this. And the standard of the elements of the offense is if the American businessman knows that that intermediary is making a payment, he's at risk of prosecution, just as if he'd been dealing directly with the foreign government official. So you cannot do indirectly what you're prohibited from doing directly.
Full investigation is the key to assuring agent integrity.
An investigation of an agent should start right at the beginning, when the company is first considering retaining that agent or otherwise entering into a contract with that agent. Conducting a thorough due diligence investigation inevitably is going to involve some street work in that country. You have to pound the streets and ask questions, look around, check the record, check the corporate records, check the legal record. An important warning sign that companies should be alert to is an agent's failure to be forthcoming with information. If a company is not able to obtain answers to certain questions regarding the agent's background, then the company should right at that moment be warned off from that agent. Another warning sign that is important to look for is an agent's lack of grounding in a certain country where he is going to be representing a company's interests. If in fact he only has a mail drop or a makeshift office in that location and has no other firm ties to that country, a company should have cause to wonder why that agent would in fact be good at representing its interests in that country.
Anyone who does business in foreign countries runs into the widely accepted practice of so-called grease payments. These are essentially tips in the form of gratuities or gifts to speed normal procedures along. Question: is it unlawful for you to grease a bureaucratic squeaky wheel?
If you're faced with a request for payment, you should get together with your general counsel and evaluate the facts and circumstances so that you can evaluate whether it's a facilitating payment and therefore would be permissible, or whether it is potentially a bribe payment and therefore would be prohibited. If it's a facilitating payment, okay, then let's document that it's a facilitating payment and what information was available.
The bookkeeping provisions of the F.C.P.A. work in tandem with the bribery provisions to uncover corruption.
Essentially, the record-keeping provisions mandate that all publicly traded companies keep accurate books and records. The concept being, if you were going to be making a bribe payment, you would try to do it in some off-book slush fund. That would be a separate felony in and of itself if you had an inaccurate record. There have been a number of instances where the government has investigated foreign payments, that is, alleged bribes of foreign government officials, and because they could not prove perhaps all the elements of a foreign payments offense, they've pursued a record-keeping provision because the books and records failed to adequately explain what had happened to the funds in question.
Case in point, you're the Eastern European representative for a U.S. agribusiness. Your management asks you to acquire a concession in a recently formed republic. Your in-country public relations consultant arranges a meeting with the president of the country at the executive palace. The president tells you he sees no reason why the concession cannot be granted, provided your company demonstrates what he calls a long-term interest in the nation's free enterprise economy. When the president leaves, the chief of staff ushers you to an antechamber. He advises that companies from other countries have demonstrated long-term interest by investing in a particular land development foundation. He introduces the head of the foundation, who happens to be the president's brother-in-law. You tell the chief of staff that you understand the foundation has no plans to develop any land, and U.S. law prohibits using a soft investment to channel corporate funds to what might appear to be a bribe to any official. The chief becomes highly indignant. He says your comment is personally insulting to the president and to the democratic principles of the new Constitution. Your public relations consultant steps in and ends the conference. As you leave the palace, the consultant says you overreacted and your concession is in jeopardy. But he's sure that the proper investment in the country's economy will mend things. You object that the investment looks like a front for a payoff. He shrugs apologetically and says, "This is the only way to do business in this country." After weeks of meeting in cafes or in foreign airports, your consultant says he has learned 2 other firms are competing for the same concession. He delivers a recommendation for an investment of $5 million in the foundation, with guaranteed approval of your concession. He stresses the necessity of keeping this payment confidential. You send the proposal in an encoded message to your home office. Reasons for investing in the development foundation are described vaguely. The payment will be buried on the books of a European subsidiary under the heading Port and Terminal Maintenance. There is no mention of the president's brother-in-law or of the tie to the concession, except verbally during a secure phone call. The investment is approved, payment is made, and the concession is awarded to your firm. During an election campaign a year later, the president's political opponent learns how you gained the concession. He informs your competitor, who retains a firm of investigators. The tip is given to the Securities and Exchange Commission. An SEC audit uncovers the false entry in the records of your European subsidiary. evidence of a possible felony is passed along to the Department of Justice Fraud Division Criminal Section. You, your home office people, and your company face discovery, interrogation, grand jury hearings, indictment.
The intentional misstatement or the intentional misrepresentation of an asset of the company, a payment of any sort, can be grounds for prosecution under the Foreign Corrupt Practices Act Books and Records provision. And the government has a number of tools, including grand jury subpoena and various administrative subpoenas, where they can obtain the company's books and records and check them over thoroughly to make sure that any payments that are being made are being properly represented on the company's books and records.
Question: how are F.C.P.A. violations discovered and prosecuted?
A prosecutor trying to build a Foreign Corrupt Practices Act case has several important tools. They can make a decision to go right in with a search warrant, seize a bunch of evidence, and interview a bunch of people. They can also take the task of serving a grand jury subpoena, and if they have a reasonable belief that the company won't destroy records, then they can wait for the company to produce those documents. It's possible to gain cooperation with a variety of countries in far-off places. We can get documents, we can get testimony or interviews by working with foreign governments and law enforcement and judicial officials in foreign countries. The person who gets paid off in a foreign country one day might be a person out of power or in need of political help the next day, and they can become a government informant as well.
Question: what are the penalties for those found guilty of bribery? An individual may receive a fine up to $250,000 and a prison term up to 5 years per count. Under the federal sentencing guidelines, calculation of penalties falls within a mandatory range, and there is no parole from prison. Under the F.C.P.A., companies are prohibited from paying fines imposed on individuals. Corporations may be fined up to $2 million per violation under the F.C.P.A. Calculated according to the federal sentencing guidelines, fines might total twice the gain from the offense. Sanctions may be imposed, including suspension of export licenses under the Arms Export Control Act. The entire company may be debarred from bidding on government procurements. Individuals and companies may face other charges growing from an F.C.P.A. prosecution.
In the prosecutor's arsenal are the general fraud statutes: wire fraud, mail fraud, 1001, which is false statement to a government agency, also conspiracy, obstruction, perjury, and the host of statutes that a prosecutor has in their arsenal. So even if a prosecutor doesn't go after a company for violating the Foreign Corrupt Practices Act, the same conduct that constitutes a violation of the F.C.P.A. can also constitute a violation of several other significant and heavily penalized statutes.
A final question: does the F.C.P.A. put American businesses at a disadvantage in foreign markets?
American executives and people doing business overseas for American companies, they know that they're governed by one standard, and that's the same standard at home and abroad. In addition, when an American company does business overseas, the overseas government and the people of that country know that that contract isn't being padded and there are no hidden payments or bribes in there, that the American company is providing value at a price that is negotiated, and what they're receiving has not been diminished in quality or the price enhanced by virtue of a hidden kickback or bribe. So over the long term, doing business in an ethical and legal fashion as set forth in the Foreign Corrupt Practices Act is good business for American companies at home and abroad. On July 31, 1998, the United States ratified an international convention combating bribery. This convention was very significant and made it necessary for the United States to amend its Foreign Corrupt Practices Act in a number of very important ways. In the past, U.S. citizens could be prosecuted for violating the Foreign Corrupt Practices Act for any action they took in the United States or in connection with interstate commerce. Now, U.S. citizens can be prosecuted for any action they take anywhere in the world, even if unconnected to the United States or unconnected to U.S. interstate commerce. They can also be prosecuted for acts they undertake while employed by foreign or non-U.S. companies. In the past, foreign or non-U.S. citizens could be prosecuted under the Foreign Corrupt Practices Act in a very limited number of circumstances. Now, foreign citizens can be prosecuted under the Foreign Corrupt Practices Act in the United States for any action they take either in the United States or in connection with U.S. interstate commerce. In the past, the Foreign Corrupt Practices Act covered payments or giving things of value to individuals who were either in a foreign government or connected with that government, running a state-owned enterprise, such as a utility or oil company. Now the definition of a foreign public official has been expanded to include officials of public international organizations, including the World Bank, International Finance Corporation, or an organization like the Red Cross. One final significant change deals with the illegal purpose aspect of the Foreign Corrupt Practices Act. In the past, payments were illegal if they were made to obtain or to retain business. Now that definition has been expanded to include any payments or offers of things of value which are made to disadvantage a competitor, payments that are made to obtain some type of preferential treatment, or gain some other benefit that might not be directly related to getting or keeping a contract, but in fact gives you an improper advantage over a competitor or any other individual. The Convention on Combating Bribery of Foreign Public Officials is perhaps the most significant development since the passage of the Foreign Corrupt Practices Act itself. Each country signing the convention is now going to criminalize conduct that previously was not subject to punishment. Each of these countries have agreed to pass legislation which is modeled in some way or form after the Foreign Corrupt Practices Act and is designed to prohibit the same type of conduct that the U.S. Foreign Corrupt Practices Act punishes. Cooperation between governments, cooperation which has been hard to get previously, is now becoming more commonplace. A working group has been established where prosecutors from each of the countries who have signed the International Convention will meet and discuss important issues. Countries will be exchanging information, exchanging evidence, and at times working together to prosecute cases. An individual who commits wrongdoing could be subject to prosecution not only in the United States, but perhaps in one or more foreign countries. The penalties for violating the Foreign Corrupt Practices Act continue to be extremely harsh. These penalties can include fines, jail time, and the loss of certain licenses like export licenses and other licenses needed to actually do business. The amended and expanded Foreign Corrupt Practices Act continues to be a very tough law, but it expands its reach to more individuals and more companies, and now it includes conduct which takes place almost anywhere on the globe.
It's clear the Foreign Corrupt Practices Act is good business. Payoffs to foreign officials are bad business, and the final payoff may be prosecution.